Greetings viewers, welcome to our YouTube channel. In the last series of videos, we have already discussed about trademark, copyright and geographical indications. If you haven't watched those videos yet, please head to the description below. The links of those videos are available there. In this video, we will be discussing about the intellectual property rights of patent. I will be covering the topics of what is a patent, the objectives behind the patent law, the principles upon which the patent law is based, what all can be patented, and lastly, the patent application procedure. Let us first understand the history of the patent law. The origin of the patent law dates back to centuries and centuries ago, but the growth of patent law is seen to have occurred since the time of late 19th century. The period of late 19th century was seen as a time of industrial boom. Industrial boom led to new inventions, and thus the Indian Patents and Designs Act of 1911 was passed in order to protect the inventors of these inventions. Today, in India, we have the Patents Act of 1970 prevailing. Now, what do we really mean by patents? The Indian Patents Act 1970 defines patents as a monopoly right granted by any government to the inventor for an invention over a limited period of time. In India, generally, a patent is granted for a period of 20 years, which can be further renewed. We know that patent is an intellectual property right, but what kind of right is it? A patent gives to the patentee the ownership right. This ownership is over the intangible property of invention. This right can further be transferred. It is pertinent for us to know what was the objective behind passing of the patent law. The objective behind the patent law is to encourage the inventor to disclose the invention with respect to which he will be protected by law so that nobody copies his invention till the time he has been granted patent. An important point to be noted is that patent protects invention and not discovery. Discovery is mere disclosure of something which was unseen, but invention leads to a new product or a new process or combination for producing an old product. An invention is a new product or process involving inventive steps and capable of industrial application. For an invention to be patented, the invention must be new. The invention must be useful. It must be non-obvious and it must be capable of industrial application. Patent law has explicitly mentioned few things which cannot be patented. These include something which is frivolous or contrary to law, contrary to morality, or even injurious to human health. What all rights will the patentee get once the patent is granted to him? The first and foremost right that he will get is to exploit the patent. Secondly, he has the right to assign the patent. He can also license the patent. He can even surrender his patent. And lastly, he has the right to sue for the infringement of his right of patent. Even though patent is granted for a period of 20 years, you can get your patent renewed before the expiry of 20 years. In order to get your patent renewed, you need to pay patent renewal fees with respect of each year in advance to the Indian Patent Office. Along with the fees, you will have to give the information of patent number, date of patent, and the year with respect of which you are paying the patent renewal fees. Rights in a patent can be transferred easily. This transfer can take place through licensing or assignment. Both in licensing and assignment, the rights can be transferred wholly or it can be transferred partially. But an important point to be noted is that in assignment, there is transfer of interest, but in licensing, there is no transfer of interest. Let us now know about the patent application procedure. First and foremost, the inventor must do a patent search. This search is done in order to know whether your invention is new or not. After the patentability search, the inventor can proceed with filing of the application. The application has to be drafted well and it has to disclose every information regarding the invention. The application must contain the background, the claims, the diagrams, descriptions, and summary of the invention. For a period of 18 months, the application is not in the public domain. If your invention is at an early stage, you can file a provisional application. After a period of 12 months, you have to file the complete application with the complete specification. After you have filed the complete specification, the application will be published and it will be there in the public domain. Now, the applicant will request for examination of the patent application. Novelty, non-obviousness, inventive steps and industrial application will be examined and a first examination report will be issued. The applicant will have to reply to the objections that are raised in the first examination report. After clarifying all the objections, the patent will be granted to the applicant. In case of infringement of your patent right, there are a number of remedies in the patent law. Some of them are interlocutory injunction, account of profit, and damages. Thank you so much for watching this video. Do like, share, and subscribe to our YouTube channel for more IP related content. Stay tuned.